Ms. Graham.
Thank you. Before lunch, we were talking about Fiona Carnan and the approach she'd taken, and I'd like to carry on in relation to some other evidence that she gave the inquiry. A topic was raised with her about her awareness of racist stereotypes in society, such as black men are more violent, unpredictable or aggressive. And she said that she had come across those types of stereotypes. She was asked, did you examine the officer's statements for language of that sort? And she said no. She was asked if she'd considered patterns of behaviour, for example, whether they'd used their sprays or drawn their batons at previous knife incidents, and she said no. Did she consider whether they treated all knife calls as potentially terrorist related? And she said no. That wasn't a question that was asked. She was asked if she'd considered looking for comparator evidence, for example, looking at Walker, Payton and Tomlinson's history of the use of spray, or Tomlinson's history of the use of force involving a baton, with a view to establishing whether those officers had ever used sprays or batons before, and she said no. She was asked whether they had used sprays or batons when detaining a white suspect, and she said no. And she was asked if she'd considered whether the speed with which officers elected to use force against Mr. Bio was because he was black. In that regard, she said, that wasn't my understanding. I think I have explained in one of the answers, my understanding of their perception was based on a whole lot more than the colour of his skin. She was then asked whether she considered whether Constable Walker and Payton decided to opt for a hard stop may have been influenced by Mr. Bio's race, and she said it wasn't a consideration per se. And she was then asked about the process which she adopted, a two-stage process, looking for evidence of criminality. You didn't find any, so you didn't get past first base. She said that was right. And it would only have been if you'd found evidence of criminality that you would have scrutinised the evidence for evidence that might allow you to draw an inference of racial aggravation. And she said yes. Now, in light of that evidence, we asked Stephen McGowan what he thought of that. And it was his view that in relation to those questions posed, that they are all relevant questions. So I have referred to looking at the totality of the evidence, and those would be questions that you would ask, and the answers to those questions would be part of that totality, which I would expect her to look at, because they're all relevant questions. Would you agree with that?
I'd certainly agree with Mr. McGowan that those are all relevant questions, the questions you've identified.
Thank you.
I'm uncomfortable about being drawn to criticise a member of staff. My approach to my role was to trust the professionalism. I thought that was a way that one gets the best out of staff, and ultimately for me to take the responsibility and answer for what they did. But I entirely agree those are all relevant questions, and the questions you asked me before the break are also all relevant questions.
Thank you. Lindsay Miller was also asked about the approach that was taken, and she said she thought that was too prescriptive an approach. It's clear from what you've read to me that she was focusing solely on the actings of the officers in relation to establishing whether or not there was evidence of criminality. But it was clear from certainly my understanding of what the Lord Advocate wanted and the discussions more generally about this investigation, and particularly what the family had asked for, that we should be examining the issue of race and the approach of the officers to Mr. Bio because of his race. Would that accord with your understanding? Does she fairly reflect what you wished to be done in relation to race?
I would have expected race to be examined fully in its where it's relevant to the issues that had to be addressed. And I can see that could cover a wide range of possible issues.
As you can see, we've discussed with a number of witnesses in relation to Article 14 in conjunction with Article 2, and looked at the issue of compliance with those articles. We've talked with witnesses about whether the Crown took all reasonable steps to unmask any racist motive. In light of the excerpts of evidence that I've read out to you today and the comments that have been made, looking at the picture that I've presented to you, are you satisfied that all questions of race and race motivation were explored appropriately during that period of Crown recognition?
I mean, I think given what you've read to me, I can't think that they were. There were clear, from what you've said, there were clearly a set of questions that to be asked. Where those would have gone in terms of a criminal investigation, that's obviously a different question, and I'm conscious is not within the remit of the inquiry. But these were relevant questions, and even if they didn't bear on the criminal decision, would ultimately be relevant in the context of any fatal accident inquiry or public inquiry that might be held.
Thank you. Certainly the evidence from Mr McGowan was that he was of the view that further steps could have been taken in relation to this, and Lindsay Miller said in evidence that with the benefit of hindsight, she was asked with the benefit of hindsight, what did she think about whether all reasonable steps were taken, and she said, I think on the basis of Miss Carnan's evidence, no. So it would appear that you agree with Mr McGowan and Miss Miller in that regard.
I do.
Yeah. Now earlier I asked you to look at a comment that was in Ashley Edwards' inquiry statement, and I wonder if we could look at that again briefly. SBPI 445, and it was paragraph 16. And I'd just like to go back to this, where race was looked at as part of the investigation with particular emphasis on the previous disciplinary record of the restraint officers. Race did not really feature in the examination of the actual restraint or the medical evidence, except in relation to the sickle cell anemia. In light of what you've now heard regarding Fiona Carnan's approach and the content of the Crown recognition, the analysis which Fiona Carnan prepared, do you have any reflections on that comment that Ashley Edwards has made? Race did not really feature in the examination of the actual restraint.
Well, I think what you've identified is a series of questions that could and should have been asked in the context of examining the question of restraint.
And earlier I said I would come back to a question I asked you. You'd said you wanted to reflect on that. I said I was going to talk to you about evidence we'd heard from Fiona Carnan, and I referred to two paragraphs within her inquiry statement. Maybe we could have those on the screen. SPPI 00379, and it was paragraphs 45 and then 38, and I'll just remind you of those. If we could look at 45 first, please. And you'll remember I asked you about this. This is Fiona Carnan's statement. She was asked about to what extent was race a factor in her analysis of the actions of the police officers. And she talked about being concerned with criminality. Her focus was on the actions of the officers during the period of their engagement with the deceased and the evidence of how they conducted themselves thereafter. she did not identify criminality on the part of any of the officers involved. And towards the bottom of that chapter, paragraph, she says, if she had identified criminality, then she would have gone on to look at whether race was a motivating factor. And then we could look at paragraph 38 again. She was asked to explain her involvement in gathering and analysing evidence in relation to the extent to which race was a factor in the actions of the officers engaging Mr. Bio. And she said she wasn't involved in gathering evidence about race if my analysis of evidence had established there was sufficient evidence to support criminal charges against any of the officers. The question of any racial motivation or intention would have been addressed at that stage. Since the analysis of evidence did not identify criminality by any officer, the question of racial aggravation did not arise, since no offence had been identified. And having drawn that sort of two-stage approach being adopted by Fiona Carnan, I asked you, did that fit with your expectations of the Crown's approach to scrutinising evidence for indicators of racial motivation or racial issues? And your reply was, I suppose the question I'm asking myself reading that is why questions of racial motivation wouldn't be at least potentially relevant to the question of whether or not the evidence supported criminal charges. I'm putting it on that way because I would want to think that through, but that's the question that occurs to me reading that. And I said afterwards I would explain a little more about Fiona Carnan's approach, and then I would come back to you and we could maybe talk about your reflections at the end. So having gone through that process and looked at the approach taken by Fiona Carnan now, do you have any reflections about this idea of a two-stage approach being taken where race and racial motivation is not considered unless criminal charges are identified or criminality is identified?
Well, having had the benefit of the process we've been through, I mean, it doesn't seem to me to be right to treat it as a two-stage process in that way. We've identified a series of questions that would have been relevant to ask. As I say,
thank you very much. I'd like to move on now to deal with the issue of experts.
Just before you leave that, could I ask you this, Mr. Wolffe? Given what you said earlier about the ability of Crown Counsel to identify gaps by reference to the primary material in the recognition, and having regard to what Crown Counsel said at paragraph 16 of her statement, would you have expected Crown Counsel herself, in reading the materials, to have identified the kind of issues that would give rise to these questions that Ms. Graham has been discussing with you?
I think having identified them as relevant questions to ask, I mean, I suppose I ask it this way: and I mean, I'm not cited on the interaction between Crown Counsel and the team, so I don't want to. Again, I want to be cautious about being critical of individuals, but. It's these are the kinds of questions that one might hope would be identified if there was a gap in the analysis, or if the analysis was structurally flawed. That these are questions that would be asked, and Crown Counsel, of course, might herself She could ask for further work to be done, or she herself could apply her mind and take a view as to whether the issue that the gap is one that, in her judgment, is one that is going to take the inquiry anywhere.
Perhaps I need to explore this with Crown Counsel herself.
Yes, I mean, I as I say, I'm acutely conscious that I have immensely experienced Crown Counsel who exercises professional judgment and, makes judgments on the basis of the material, available to her or him in any individual case, we've identified in the material that Ms. Graham has put in front of me a series of questions that I've accepted are, on the face of it, relevant questions to ask, and would be relevant questions to ask, at all stages of the inquiry. Having done that, yes, one might want to think about whether Crown Counsel should have identified those questions or not.
Thank you. Ms. Graham.
Thank you. I'd like to ask you some questions around the issue of experts. We've heard evidence a number of experts were instructed by the Crown as part of this process of the Crown investigation. And I wonder if we can look first of all at COPFS 05687. And we've heard evidence that there is a knowledge bank available in Crown Office for staff. We've heard about a book of regulations, Precognoser's Handbook. This is a document that is part of the serious and complex case guidance, and this particular chapter relates to expert evidence and the role of the expert. I don't know if you recognise this guidance that was available.
I would be aware there was guidance. I'm not sure I can say that I recognise this particularly.
But you recognise that there was guidance available to staff in relation to the expert evidence?
Well, certainly in relation to a wide variety of issues, I would have expected it to include expert evidence.
I wonder if we can just very briefly look at a part of this. Page 8, it's a 14-page document. Page 8 that I'm interested in, and it's section 8.6.1. And this guidance says, the use of the consultation to establish and confirm expertise is discussed at paragraph 8.1. This is a vital step and must not be overlooked or rushed through. And there is a presumption that Crown experts will be consulted with in High Court cases. And case investigators should aim to consult with the Crown expert witnesses prior to the case being reported to Crown Office for Crown Counsel's instructions and indicting. Where an allocated AD has been identified, then the consultation should ideally be conducted with that allocated AD and the case investigator both present. And as a general statement of principle, would you agree with the comments within this guidance?
Yes, I mean, it certainly makes sense.
For example, using a consultation to establish and confirm expertise, would you agree it's important that an expert has the necessary expertise
of course,
before he or she gives opinion evidence to the court?
Yes, of course.
And the presumption that Crown experts will be consulted with in High Court cases, do you have any comments about that?
Well, it's always sensible to consult with an expert if circumstances permit. Whether that, I mean, I suspect that in the generality of High Court cases, there are probably many situations where, for a variety of reasons, that won't happen. It may be because the evidence is of a relatively standard nature or for other practical reasons?
There is other guidance available. I won't take you to it, but it is in a trial, if the defence agree the expert evidence and it's incorporated into a joint minute, there wouldn't be any need to consult necessarily.
Yes, and I have to confess, as an advocate depute, I will have prosecuted High Court trials involving, let's say, relatively standard forms of expert evidence, if I put it that way, where I may not have consulted with the expert.
Right, thank you. And then it talks about case investigators should aim to consult with experts prior to reporting, or where an allocated AD has been identified. Ideally, the consultation would be with the allocated AD. And is that the type of approach you would expect to be taken in a serious and complex case?
Absolutely makes sense, and the opportunity for the prosecutor who one expects to conduct the trial to have met the expert and had the opportunity to test and ask questions is a valuable one.
We have heard that there were consultations with the allocated AD. And then it says an advocate depute may conduct a consultation without the presence of the case investigator if he or she considers that appropriate. And why would that be a matter of comment in the guidance?
It may be because in the normal, if one takes the situation away from the prosecution of crime to other parts of the justice system, counsel would normally consult with a solicitor present, and I suspect that this is signalling that in this context, an advocate depute may, if he or she considers it appropriate, conduct the consultation without the case investigator being present.
Thank you. And then can we look at the bottom of page 8? In fact, it mentions here in solemn cases there's a presumption that a consultation should be conducted with all Crown expert witnesses, including expert medical witnesses, unless the evidence relates to routine forensic analysis of drugs, confirmation has been provided by the defence that the evidence will be the subject of agreement, or a satisfactory statement from a medical witness has been submitted by the police in accordance with the serious crime protocol. In terms of when you were a Lord Advocate, was there a presumption that a consultation would be conducted with all Crown expert witnesses, including medical expert witnesses? Is that something you were aware of in practice?
I'm afraid I can't say what the guidance was when I was Lord Advocate. The examples given there of situations where one might not conduct a consultation are generally consistent with what I described earlier.
So, out with those exceptions or examples where a consultation wouldn't be required, would you expect an allocated AD to conduct a consultation with all Crown experts?
Well, it's stated as a presumption, so assuming that was the guidance at the relevant time, then that would be, I suppose, if one put it this way, the norm, but not an absolute rule.
Thank you.
That's what I take from that. I should say I'm simply reading what's on the page.
Now, we've heard evidence that after the final PERC report was received in August 2016, and initially that in 2017, from March to August 2017, Crown Office instructed 3 experts, a Professor Anthony Fremont, who was an osteoarticular pathologist, a Dr. William Lawler, who was a forensic pathologist, and Professor Michael Edelstein, who was a clinical toxicologist and pharmacological. I mucked that word up. Pharmacologist. I'd like to ask you about some evidence we've heard from Les Brown about the instruction of experts, and particularly in relation to the involvement of Dr. Lawler, who was a forensic pathologist. And I'm hoping you can help us with something. Mr. Brown in evidence referred to the Lord Advocate, and he talked about guidance or advice or a discussion with the Lord Advocate about the instruction of an expert who could be a reviewing expert. Now, he said it may have been Lord Mulholland, but obviously at the point in time when Dr. Lawler was being instructed, you were the Lord Advocate at that stage. So Dr. Lawler was instructed for the first time on the 28th of March 2017. So not quite a full year after you'd been in the position, but almost a year. And I'd like to tell you about the evidence of Mr. Brown and see if you think it was you or if it was not you.
I mean, I can say now I have absolutely no recollection of it, but you know, if it emerges from other evidence, then you know, so be it.
So Mr. Brown talked about Dr. Lawler being instructed, a forensic pathologist, and he's described him as a reviewing pathologist, and he said that was the course of action that had been, I think, suggested by the Lord Advocate at an early stage in the investigation. It was within the consideration that there would be some advantage in having a pathologist who would be able to take a view independently on all of the pathology evidence that had been obtained, with a view to, I suppose, coming to a conclusion as to what this amounted to, and if there were differences, which area they could offer useful comment on. And this was the context in which Dr. Lawler was ultimately instructed. And he said that is how Professor Lawler's name came up, and at the time that Crown Counsel were wanting to identify a reviewing pathologist, the full CV of Professor Lawler was forwarded, as I recollect it, to Ashley Edwards, and Ashley Edwards considered that and approved an approach being made to Dr. Lawler. So again, it appears at the time Ashley Edwards was the allocated AD in place, which is when you were Lord Advocate. He said, I can only say that I personally have not had experience of that, but as I indicated, the intention to consider and approach a reviewing pathologist was something that was clearly considered by the Lord Advocate. And he said he thought it was Frank Mulholland as he recollected it, and that raised the question of the benefit of having a reviewing pathologist. So I just wonder if that description or that evidence from Mr. Brown, does that prompt any recollection on your part of having a discussion about this role?
I'm afraid it doesn't ring any bells. As I say, I do have a poor recall. I found when I was doing statements for the UK COVID inquiry that I had poor recollection of events which one might think were significant. So the fact that I don't remember something, is not necessarily evident. Doesn't necessarily mean it didn't happen. But none of that rings any bells to me.
All right. Well, I've got a few questions to ask you about Dr. Lawler, who was instructed at the time you were Lord Advocate, and I'll see if you can assist. I wonder if we could look at his first report. This is COPFS 00033. You'll see there at the top of the page his name, Dr. William Lawler. He's a forensic pathologist, and it's dated the 22nd of May 2017. And it's sent to Mr. MacLeod, Senior Procurator Fiscal Depute in Crown Office. Do you see that?
Yeah.
And it's, if we can move down the page, please. He refers to the invitation to review various reports. And he's been asked, you'll see at the bottom of the first paragraph, I agree with whether or to what extent I agree with the conclusions and findings of the others who've been instructed. He then lists the materials, and if we can look further down, please. And then the background is noted by him. He's been sent a number of documents to assist with that. And then if we look at page 8, please. And it says, I have been asked, if we can maybe go to the top of page 8. I have been asked as a forensic pathologist to comment upon the pathological aspects of this case, including methodology and approach adopted, and specifically whether or to what extent I agree with the conclusions and findings of the others who have been instructed. And if we can then look at page 9, he says, may I say at the outset that I have no criticisms of either the methodology or the approach adopted by Dr. Shearer and Buhadir in this case, or indeed of anyone else instructed. We've heard evidence that Shearer and Buhadir were the pathologists who carried out the post-mortem in relation to Mr. Byes. And then if we look at page 11, please. I'm not going to take you through the whole report. I'd like to look at the section that deals with Dr. Lipsitch, which is, here we are. Dr. Maurice Lipsitch. Dr. Lipsitch is an emeritus consultant psychiatrist, and he addresses the deceased's mental state, particularly in the context of the drugs which he was known to have taken. And then if we can look on to page 12, he summarises Dr. Lipsitch's report, and he says, comments. This expert confirms what I, as an acknowledged non-expert in this field, had concluded. And I don't want to ask you about the conclusions or the comments that are given, but you'll see there that Dr. Lawler, as a forensic pathologist, is being asked to comment on the report of a consultant psychiatrist. And I'm interested in any views you may have about the value of that to the Crown. You're smiling.
Well, simply as a matter of the law of evidence, an expert is qualified to give opinion evidence only in areas in which the expert has expertise. And to the extent that our witness offers opinion evidence on matters where they don't have expertise, that evidence is not of any evidential value. Or it's not evidence, I suppose.
So it's not of any evidential value. In fact, is it even admissible evidence?
No.
Thank you. And do we see on page 14, he's also asked to comment on the report of a Dr. Bleetman, a consultant in emergency medicine. And, in the comments section, it may be that I'm talking about the PDF. There it is, comments. Dr. Bleetman provides what I, as a non-expert, consider to be. So again, he's not an expert in an expert consultant in emergency medicine, but again, he's being asked to comment. Is the position the same in relation to this specialism?
Well, he says he's a non-expert. I suppose it slightly depends what the reviewing expert is being asked to do. I have been involved in a case entirely in a different context, in a civil case where we had the benefit of what one might call a coordinating expert who drew together, was helpful in the instruction of other experts, who was able to provide some informed commentary from a perspective of someone skilled in a scientific discipline on the quality of what had been provided. So not in a position to provide opinion evidence, but in a position to give some quality assurance or not of the quality of what was being done by others. So that's I think that's a different exercise from the one that you're looking at here. But I offer that simply as something from my own practicing experience.
Thank you. And then on pages 23 and 24 of 26, we should see the heading Professor Anthony Fremont. There we are. Professor Anthony Fremont, who is an osteoarticular pathologist. You may know this, we've heard evidence from Professor Fremont, and he specialises in bone pathology. So it's a very, as I understand it, quite a particular area of specialism in that field. And we also heard evidence from Professor Fremont that when he decided to retire, the Home Office asked him to assist training others in the field because the UK did not have a lot of osteoarticular pathologists. And again, Dr. Lawler, if we can look at the comments section, says, admittedly, this is not a matter within. Yes. So look at the overview section, sorry, and if we can look, number 1, although admittedly not within my field of expertise. So again, he's highlighting that, again, this is not an area within his particular expertise. Oh, sorry, that's maybe the wrong page. Can we look further up, please? I think I've missed the section. I'll have to come back to that. I think I've got. Oh, can we look at the? No, I've lost my number, my page number. I'll come back to that in a moment. But again, do you have any concerns about Dr. Lawler, a forensic pathologist, being asked to comment on a specialism of osteoarticular pathology?
Don't know enough about the interaction between those two disciplines, if it, as to whether there's any value to a pathologist of one nature commenting on views by a pathologist of another related discipline. But if he says himself he's not an expert in the field, then that's that answers the question, I think.
Yeah. And then can we look at a supplementary report by Dr. Lawler, which is from 13th of August 2017, COPFS 00034, and page 2 of 6. Again, there's reference there to Professor Fremont. Here it is. Although I readily accept that I am not a specialised osteoarticular pathologist, I do have a career background of diagnostic histopathology, albeit a long time ago. So again, he acknowledges that he's not a specialist in that field, but he did have a background in diagnostic histopathology. Is that something you would have expected would be explored in some detail in relation to the value of any comments Dr. Lawler makes in relation to Professor Fremont?
Yes, I mean, on the face of it, it's something one might want to explore with the author. Yeah, what one might take from any comment that he makes.
And is one of the possibilities that he simply isn't in a position to comment on Professor Fremont's opinion? Because he doesn't have that specialism himself.
Either he doesn't have the specialism, or his, to the extent he has an expertise, it's out of date, or to the extent he has an expertise, it's at a lesser level than that of the person he's commenting on. There could be various possibilities.
Thank you. And then can we look at page 4, please? And I'm interested in the comments about Professor Michael Edelsten. You'll see that there's a section relating to him. There we are, Professor Edelsten, who is a consultant clinical toxicologist and had been asked to consider effects of drugs taken by the deceased prior to his death. And then if we look at page 5, and you'll see that there's a comment section. Although Professor Edelsten's area of expertise is significantly different from mine, I found his report very interesting. Again, can you help us with understanding the value of that to the Crown?
I mean, not quite sure what the context is, but I suppose an expert in one discipline may read a report from an expert in another discipline and find that illuminating in terms of what they've been asked to comment on. But whether that's what he's saying or simply a more general observation about it being interesting, I can't say.
Certainly at the outset, in relation to his instructions, he was asked to comment on methodology and approach adopted, and whether to what extent he agreed with conclusions and findings of others. Mm-hmm. Would you have concerns, given the area of expertise of Professor Edelsten is significantly different from that of Dr. Lawler, would you have concerns about the value of any comments he did have regarding methodology or the opinion of Professor Edelsten?
Well, again, I'm, as it were, speaking very much in the abstract. He clearly can't give expert evidence in an area of expertise that is not his own area of expertise, whether as a skilled scientist or medical scientist. He's in a position to provide useful comment on, as it were, issues of general methodology. I can't say.
Dr. Lawler did not disagree with any of the forensic pathologists who were of the same specialism as he had. Mm-hmm. And that included Crane, Carey, Shearer and Bouhadir. Do you have any recollection now of why so many forensic pathologists were instructed by the Crown?
I don't, I'm afraid.
Dr. Lawler was instructed first of all in March 2017. His final report was received in May 2018, some 14 months later. Considering Article 2 obligations and avoiding delay, and in light of what I told you, do you have any concerns about the period of time that this reviewing pathologist, the involvement of Dr. Lawler had in relation to the period of time that the Crown investigation took?
Well, I suppose the starting point is a general concern about the time that the investigation took. As I've said in my statement, not unusual, and I'm not cited on the detail of why the investigation took the time that it did. I am aware from the subsequent work that was done generally into death investigations that the availability and response of expert witnesses is often a significant factor in delay. It sounds like a very long period of delay, to await this expert's view. I'm afraid I haven't quite been following sufficiently the points you've been taking me through to really comment on the value or otherwise of his, what he's got to say in the area in which he is an expert. So not sure I can really assist beyond that.
I'd like to move on then and ask you about another expert who was instructed by the Crown, Dr. Stephen Karch. And you've been asked about Dr. Karch in your inquiry statement. And certainly Dr. Lawler was also asked to comment on Dr. Karch. Could we look at your... Could we look actually at the questions that were posed to you in relation to the inquiry statement? So this is the Rule 8 request, which is SBPI 00438. And could we look at question 20? And it says, were you aware of any issues relating to Dr. Stephen Karch that were apparent from a time prior to your involvement in the investigation? Were you aware of Mr. Byles' family's views of Dr. Karch? And were you aware of any media statements attributed to Dr. Karch? What were the previous Lord Advocate's views of Dr. Karch as far as you were aware? And how, if at all, did any of these matters affect your understanding of Dr. Karch and his opinion? And you'll remember being asked about that. And then if we look at your response, your Rule 8 response, which is 529 and paragraph 53, I have no recollection of the issues referred to in this question. If they were drawn to my attention, I would expect that to be apparent from the documentary record. So do you have any recollection at all about issues being raised with you regarding Dr. Karch and his instruction?
I'm afraid I have no such recollection. Now, I suppose I should qualify the second sentence that, I wouldn't, if something was mentioned to me in an oral briefing or orally, I wouldn't necessarily now remember it.
Right.
But I've absolutely no recollection of any of the points or issues raised in that question.
Well, we've heard evidence from Stephen McCowan and from Mr. Les Brown about Dr. Karch in connection with there being issues about the funding, the source of funding of his research, and whether that had implications in relation to his objectivity. We've heard evidence from them in relation to a newspaper article which appeared where Dr. Karch had made comments about Mr. Bio and the investigation to the press. And we've heard evidence that I think the then Lord Advocate, who was Frank Mulholland, had been concerned about Dr. Karch, about his engagement with the press, about engagements with his instruction, and that had also been reflecting concerns that the family had about his instruction, his views on excited delirium, and those views had been reflected to Crown Office through their lawyer, Mr. Anwar. We've also heard other evidence that in fact Dr. Karch is not a forensic pathologist, he's not carried out any autopsies. He has no formal toxicology qualifications. And does any of that, the information I'm giving you, prompt any memories or recollections on your part of being advised about Dr. Karch or any of the previous concerns?
I'm afraid it doesn't.
Right. You've said that you would have, if they were drawn to my attention, I would expect that to be apparent from the documentary record. Thinking about when you were Lord Advocate, are these the types of things you would want to know about an expert if he was being instructed by the Crown?
I suspect it depends what was being done about them. I would not expect to be routinely or indeed at all made aware of concerns about an individual expert in an individual case. I would rather expect Crown Counsel to make a decision about what should be done in relation to that expert. If there were if there was a particular reason to do so, then either the Crown generally or Crown Counsel could raised the issue with me, and I can imagine there might be a situation where there, let's say, again speaking generally, there are concerns about an expert, but Crown Counsel takes a view that, for a good reason, that the expert should be instructed, but wants to have, in effect, reassurance of that law officers are aware of the issue. I could see that happening. I don't remember it happening in this case, or indeed in any other. It's the kind of issue that I would expect counsel, in effect, routinely to be alert to questions of independence, expertise, and for counsel to, who have the full authority to do so and are allocated to the case, to make the decision that is appropriate and to make the judgment. The judgment call is for them, unless there's a good reason to bring it to law officers. Given the particular sensitivities of this case, I could see such an issue being brought to law officers potentially. But as I say, I'm afraid I have no memory of that happening.
If your predecessor had indicated the Crown would not rely on an opinion from Dr. Karch for many of the reasons I've discussed with you, would you expect that to be an issue that was raised within the Crown recognition, either in the narrative or the analysis, when it came to highlighting issues regarding Dr. Karch?
I mean, if it was known to the authors, I would have thought so. But if my predecessor had taken a view that particular experts should not be instructed or relied on, then I would have a question in my mind about why it features in the Crown recognition at all.
And would you expect that sort of information, that a Lord Advocate has said we're not relying on this expert, to be drawn to the attention of the precognosers?
I would have thought so, yes.
And would that be the case even if they didn't get involved until after the comment had been made by the Lord Advocate, sometime after?
I can see how, I suppose when you put it that way, I can see how the precognoser might not be aware of the point, and I suppose that leads me to a set of questions about how within Crown Office that information would be disseminated.
And I'm interested in your thoughts about how that sort of information could be disseminated, and not just for those involved at that moment that the comment may be made or the decision taken, but for the future staff who may come in at a later stage. Do you have any procedures in place, or did you have any procedures in place, or was there any process whereby something like that being said by a Lord Advocate could be noted and had regard to by others?
I don't recall any, as it were, specific process or procedure. I can envisage, I suppose it might depend on the context in which the statement was made. If it was written down, one might expect it to be, the written record to be available. If it was said in a meeting, I suppose it would depend on the record and the recollection of those in the meeting. There's an interesting question, I suppose, about how one ensures that in a case which is being investigated within the police or the park, but with Crown engagement and then a subsequent Crown investigation, how one ensures that there's a sort of continuity of knowledge and understanding and appreciation of any points that have arisen from one to the other. I have to confess, I suspect that didn't even occur to me at the time. I would have assumed that the the system would ensure there was appropriate continuity.
So there's not just the issue of a Lord Advocate saying we're not using this particular opinion from this expert, and the issue of how that is communicated to subsequent recognosers who may or may not become involved in the matter, but also the other implications about how would Crown Office ensure that that expert, if there are serious concerns about an expert, how that would be communicated amongst the wider staff in Crown Office, that maybe this is not an expert we would be inclined to go to again. Is there a blacklist of experts that's prepared?
I have to confess I'm not aware, but when you put the point to me, I entirely, I can entirely see that there should be, that if there's an expert who, for one reason or another, has proved to be not acceptable, that there should be a way of making sure they're not used subsequently. Let's say there's an expert who's been found to be or been the subject of serious criticism by a court. Crown might well not want to use that expert at all because of the risk that would present to criminal proceedings, and having some form of database or record that allowed that to be disseminated and double-checked, I suppose, would be a useful thing.
Thank you. I'm conscious of the time, if that might be...
We'll take a 15-minute break. Graham.
Thank you. I'd like to move on to the instruction of further experts that took place in the Crown Office in 2018. And there's evidence available to the inquiry that at that stage, a Professor David Rees, a Dr Elizabeth Solyu and a Dr Sebastian Lucas were being instructed by the Crown. And they were looking into histopathology, sickle cell anemia, issues of that sort. It was during 2018 that, as we understand it, consultations took place between the allocated AD and the head of CAPD with various experts. And I'd like to ask you again about something that we addressed prior to the break. When we were looking at the guidance available in relation to expert evidence, you may remember the use of the consultation to establish and confirm expertise was described as a vital step that must not be overlooked or rushed through. Do you remember I asked you about
Yes.
that? I won't put it back on the screen unless you wish. We have copies in the inquiry of consultation notes that were taken during the course of a number of consultations with experts. It would appear from those notes that qualifications and experience was not part of the discussion. Now, I fully appreciate we've not yet heard from Ashley Edwards in relation to how she led at consultations. But would you have expected at consultations with an allocated AD and someone from CAPD to consider issues of qualifications and experience in relation to each of the experts?
Well, as a generality, I can really only speak to my own practice. If one consults with an expert, the first thing one wants to address is their relevant experience, expertise, qualifications, and so on. Obviously, in an individual case, that may be so obvious that it doesn't need to be addressed. In other cases, it may need to be explored in detail. I mean, that does strike me as the sort of thing that's ultimately a matter of judgment for Crown Counsel. And I appreciate the guidance is sound guidance, but one is dealing with an extremely experienced professional advocate who will have dealt with many expert witnesses and will have made her own judgment about what she needed to cover.
And in your own experience, what are the types of situations where you would feel comfortable not going into detail with an expert about their qualifications or experience?
I suspect if it's a relatively routine area of expertise where the expert's qualifications are patent, or possibly in other cases where the experts set out, in reasonable detail in their report or otherwise their qualifications. I can easily envisage cases and think of cases where I wouldn't think it was necessary to explore those issues.
And presumably if an expert is regularly appearing in the High Court in Scotland and you perhaps have questioned that witness on a number of occasions, presumably that's another occasion when you may not need to go into their qualifications and experience.
Indeed, I mean it's I wouldn't be prescriptive, and I think as I say, the guidance is very sound guidance, and one has to, I think, bear in mind that that's probably guidance being directed at staff, professional staff, but professional staff at all levels. When one has very experienced counsel, It's not that they throw the guidance out by any means, but experienced counsel exercises judgment and experience all the time in relation to the way they conduct particular matters.
But in the absence of the examples we've discussed now, the guidance is good guidance, good practice, and it's always worthwhile checking the expert's got the right experience and expertise.
Absolutely, and the starting point is an expert. Any witness can only give evidence of opinion if they have appropriate expertise, and so you want to confirm that if it's not clear.
And an expert, it's only admissible evidence, the opinion evidence, if they do have those skills and qualifications and expertise.
Absolutely.
And one of the obligations of an advocate depute would be to satisfy the court that evidence from that expert in relation to their opinion would be admissible and relevant to be heard in the court proceedings.
Well, indeed, you would need to establish the witness's expertise before leading their evidence of opinion.
Thank you. So, in relation to consultation notes which we have, which do not explore issues of qualifications and skills and expertise, if those issues were not addressed, would you be concerned that that wasn't being thoroughly looked at, subject to leaving aside obviously all the examples where it might not be necessary?
Well, I think all I can really say in the abstract is that it perhaps invites a question as to whether it was necessary to do that exercise.
All right. Thank you. And if the allocated AD was conducting the consultation with the expert, that question should probably be directed to her rather than you.
Well, I wasn't present. I can't speak to what was done. And equally, I had an immensely experienced senior Crown Counsel conducting the case, and it's the nature of that role that one is exercising professional judgment all the time, and I would not expect to have to interrogate the way in which she is exercising that professional judgment. I would rely on that and trust that, accepting, of course, that I'm answerable constitutionally when I was Lord Advocate for that trust.
Where there is a consultation and it's conducted by Crown Counsel, and we have heard that Les Brown would often attend with the allocated AD. However, Fiona Carnan would not attend, and I'm interested in your views on the precognoser who's preparing the analysis is not at consultations with the allocated AD, with the experts, and whether you think, reflecting on that approach, whether that's a disadvantage for the precognoser, who's not been party to those discussions, often about complex issues.
Put in the abstract, I can certainly see that it could well be a disadvantage. Yes, I mean, if the issues in the report are being explored and investigated at consultation, it's going to be helpful for any member of the team who's then going to have to, as it were, use that information to have been party to those discussions. But I put that very much in the generality. But again, I'm not having been party to that kind of precisely who was attending what meeting. I'm not sure I can be more specific.
Generality. And then where, in this case, Les Brown attended with the allocated AD, what would your expectations be in relation to sharing information about that consultation, either by the allocated AD or by the head of CAPD with the precognoser who was working on the analysis? Would you expect there to be some sort of discussion or meeting or handover, or would you be comfortable with them relying on consultation notes? Do you have any thoughts about that?
I suspect it depends very much on the particularities of any individual case. I mean, and there may be cases where a note of the meeting is sufficient, or where the issues explored didn't reveal, as it were, new material which needed to be drawn to the attention of the precognoser. Equally, there might be other cases where one would, if the individual hadn't been present, you might, in the ideal world, want some form of oral explanation. I think it's very hard to be prescriptive, and I think it would be quite wrong of me, from the role of head of system, to be put in a position of seeking to comment on what one might regard as matters of very fine case management.
Thank you. One other aspect in relation to the experts, we've heard evidence from Les Brown about consultations which he attended with Ashley Wise and on his own. And then I asked him about some other experts who there were no consultation notes in relation to them, and should we assume that there were no consultations? And he thought that was a reasonable approach to take. Do you have a concern about the fact that it appears that nobody from the Crown consulted with these experts, so Dr. John Parks, Dr. Maurice Lipsage, Dr. Sebastian Lucas, Dr. Payne James, Dr. Mary Shepherd, Professor Jack Crane, Dr. Nat Carey, Professor Anthony Fremont, or Professor Michael Eddleston? So there's quite a large number of experts there where we have no consultation notes, and it would appear from Les Brown's recollection that they were not consulted with. Do you have any thoughts about the absence of consultation with experts where they've been instructed?
It very much depends on the nature of their evidence, the issue they're addressing, and the clarity and clarity of the opinion that's being expressed. I'm not sure I can really answer the question in any sort of abstract way. Again, it perhaps invites a question about why there wasn't a consultation with particular experts, but I've certainly in the past been in a position of taking a view that there was nothing I could usefully spend time with the expert asking the expert, because the issue was clear and their expertise and everything else was adequately patent from a written document.
So again, do you think that perhaps if the inquiry is looking for further information about this and further explanation, that Ashley Edwards would be the person to speak to about that?
I think you'd have to speak to those who were involved in setting up the consultations, deciding whether or not to consult with particular experts. And I would be relying on their professional judgment.
Thank you. I'd like to move on and ask you about a different type of expert. Perhaps we could look at paragraph 52 of your inquiry statement. And this relates to an expert in relation to restraint. There we are. And can we just see the question just above that? Again, it's about expert witnesses, and you were asked what involvement, if any, you had in the instruction of experts. And then if we can move down, and your paragraph 52 says, the documents which have been provided to me by the inquiry contain an email exchange between my office and APCC in December 2017 in relation to the identification of a suitably qualified restraint expert, in which I suggested that inquiries might be made with police forces elsewhere in the UK and with police training institutions north and south of the border. Otherwise, so far as I can recall, I had no personal involvement in the matters referred to in this question. These were all matters for the investigative team under the direction of APCC. As I have already noted, when I received APCC's report with a recommendation in relation to prosecution of the officers, I had a discussion with her which resulted in further consultation with a restraint expert before a final decision was taken. I cannot now recall the specific point upon which I considered that further work was required. So you had some involvement in relation to the restraint expert.
Yes, I mean, the exchange which is recorded in the documents it indicates that the team had been having difficulty identifying a suitable restraint expert, and I'd suggested the inquiries that are described there, and then I think there's, if I remember it correctly from the documents, I think there's then an exchange where there's a question of whether I had someone in particular in mind, and I didn't. You know, it was simply that I was encouraging the team to look Firth of Scotland and to those institutions described in order to find somebody who could suitably and independently comment from a restraint point of view.
Thank you. It may assist if we look at the moment at COPFS 02126A, and this was a briefing note that was prepared by Alistair MacLeod at a later stage, and you'll see it's dated 28th February 2020, but it covers the period of the Crown investigation from the 3rd of May 2015, which is the date of Mr. Bio's death, to the 11th of November 2019. I wonder if we could look at page 13 of this. And it deals with what's called the OST expert, so that's Officer Safety Training Expert. And it summarises the issues that the Crown experienced during this time. The Crown encountered considerable difficulty in identifying a suitable OST expert. And a number of inquiries were made in England and Northern Ireland, and the approaches were made to the Metropolitan Police College in Hendon. Do you see all of that?
I do, yes.
And then there's mention of details of a known and trusted former training officer, Martin Graves, now operating as an OST expert in the private sector. Were you aware that Martin Graves had been instructed by the Crown?
I was certainly aware that an expert had been instructed. I don't now remember the name.
Mr. Graves was contacted in December 2017, and the following day he forwarded his CV and confirmed he would be in a position to start reviewing materials. And then during January 2018, there seems to have been a view that he would be able to provide a report. He was contacted by telephone in January and given specific details about the case. And then you'll see he was given a detailed letter of instruction. And then if we can move on. The original materials provided to him in January included documentation in relation to the training delivered to the material officers. And then there was further communication with Mr. Graves over a period of time. And there appears to have been some issues about whether he could provide the report as instructed within that period of time. If we can move on. And then it says, this was with a view to finalising the report to Crown Counsel by the 23rd of March 2018. Although the consultation with Mr Graves was very useful, he advised the Crown that his report would not be completed until April 2018. And as a result, it was decided not to submit a report to Crown Office until Mr Graves' report was received and assessed, and other investigations were ongoing. And then if we move on, it says the report was received on the 14th of April 2018. There were a number of typing and dictation errors and a number of points about factual accuracy that were also raised with Mr Graves. And after consideration of the points raised by the Crown, his initial report was treated as a draft, and he submitted his final report at the end of April 2018. And he was then precognosed by the precognosers on the 11th of May 2018. So he was initially instructed. He prepared what became known as an interim report. After further discussion, there was a final report. He was consulted with by Crown Counsel, and he was also precognosed by the precognosers in May of that year. And is that the type of engagement with Crown that you would expect an expert in relation to restraint or officer safety training would have in this type of investigation?
Again, there's nothing there which strikes me as surprising, if I put it that way. Mm-hmm. The precise approach to any particular expert will obviously depend on the circumstances and the judgment of the professionals involved as to what's required. But there's nothing in what you've shown me that I find unusual or surprising.
Thank you. Could you now look, please, at the letter of instruction to Mr Graves, COPFS 00008. And this is a letter of instruction to Mr Graves dated the 24th of January 2018. And on page, there's a reference to recent email correspondence and telephone calls with Alistair MacLeod, who was the precognoser at that time, and an introduction to the work that the Crown are doing. Could we look at page 2 of 12, please? And there's a passage in bold there. Given your expertise, the Crown wish to instruct you to prepare a report commenting on the actions of police from the point of engagement with Mr Bio, and particularly providing opinion on whether the method of engagement with and restraint of the deceased by officers was reasonable and justified, taking into account the requirement for their use of force to be necessary, accountable, proportionate, legal and ethical. In general, in providing your opinion, please comment on whether the officers concerned seem to have followed their OST training. We would ask that you consider all of the materials supplied to you in reaching your opinion. And so he was instructed in this letter to prepare a report in relation to those matters. And then you'll see that there's a list of materials that were enclosed. You'll see a large number of documents included. I don't want to go through these in any detail, but if we can scan down the page. And a number of statements are also provided to the expert that we can see listed. A composite disc, maps, 999 calls, airwave recordings, photographs, that type of thing. It's all detailed in this letter. And could we look at page 7 of 12, please? At the section restraint on the ground. There we are. Restraint on the ground. You will notice that on the composite CCTV timeline, a stop clock appears on the left of the screen at the moment when the now deceased is taken to the ground and stops at 4 minutes and 2 seconds when PC Smith contacted Force Control to ask for an ambulance for the now deceased. So there's some description there of what can be seen on the CCTV timeline that's been provided by the Crown to Mr Graves. And then there's also reference in the second paragraph to Snapchat footage taken by witness Wise. It contains a brief glimpse of the methods of restraint being used at that time. 6 officers are in various positions on around the now deceased. From that Snapchat footage, it appears that Mr Bile was lying on the southern pavement on Hayfield Road, surrounded by 5 police officers, namely PC Smith, Tomlinson, Creighton, Gibson and McDonough. A 6th officer, believed to be PC Walker, appears to be lying lengthwise on top of or beside Mr Bile, his high visibility clothing visible momentarily. And then it goes on to describe other matters and also talks about handcuffs and fast straps. So do you see that section there that we can see on the screen? It appears that in sending the letter of instruction to Mr Graves, the Crown have highlighted within the Snapchat footage that it appears Mr Bile was lying on the pavement, 5 officers were surrounding him, and a 6th officer, believed to be PC Walker, appeared to be lying lengthwise on top of or beside Mr Bile. Do you see that?
Yes. That's
raised specifically by the Crown. Could we look now please at Mr Graves's report, COPFS 00024. And you'll see that this is instructed by Mr MacLeod. The expert is Martin Graves, and the date of it is 13th April 2018. And I'd like to go through some aspects of this report with you, and then I'll ask you some questions at the end. Could we look at page 30 of 41, please? And if we look at letter S, so it'll just be at the bottom there, he notes this is a section in the report where Mr Graves is beginning to draw out factors that he's taken from the documents produced to him by the Crown. And I'll just go over these very quickly. S talks about PC Walker, who fell to the ground at this time, dropping the baton he'd taken from his colleague. He states he ended up on his knees next to Mr Bile, who was on his back. And then if we can look at page 31, and I'm interested in D and E. The whole restraint period appears to have been no longer than 4 minutes. While this may look like a long period for 3 or 4 officers to get someone under control, I have examined many such incidents, and this is by no way a prolonged period of time. Do you see that?
Yeah.
And then E, at the start of this process, PC Walker describes the subject lying on his left side with him behind, that's Walker behind, on his knees. He states he attempted to get hold of Mr Bile and he was placing some downward pressure on his shoulder with his upper body. So this is a description given by PC Walker in documents that have been sent to Mr Graves for consideration. And then at J, please. At this time, there are differing accounts of the body position of Mr Bile. PC Tomlinson, Smith and Mr Nelson appear to have him on his front, with PC Walker lying over his upper body. PC Walker describes this as being on his knees with his upper body over the subject's right shoulder, with him lying on his left side. So this is where Mr Graves notes that there are differing accounts that are available to him in the Crown Office papers. And on the one hand, there are statements from PC Tomlinson Smith and a statement from Mr Nelson, who have Walker on Mr Bile on his front, with PC Walker lying over his upper body. And a differing account, however, is given by PC Walker, who describes this as being he was on his knees with his upper body over the subject's right shoulder, with him lying on his left side. Lying on his left side. And then if we can look at L, please, which is on the next section. I would also be very surprised that during this time PC Walker was not at times lying across the upper body of Mr Bile and putting a degree of pressure onto him. I do not think this could have been sustained or prolonged pressure due to my comment in the next paragraph. PC Tomlinson provides an example of this when he states that Mr Bile was bench pressing PC Walker, who is a substantial weight, off the ground. In this position, the fact that PC Walker was on his back would not have placed any pressure on his chest if this was not on the ground, and Mr Bile would have been able to breathe in this position. Then V for Victor. Whilst I am not a medical expert in such matters, I have dealt with and reviewed many such cases, and this is not one that jumps out as a typical case of positional asphyxia. It does have some of the hallmarks, but due to the short time of restraint, 4 minutes, the constant movement of Mr Bile, and his opportunity to take breaths during the restraint process, I do not believe this was a major contributing factor to his unfortunate death. And then I'd like to look at the summary of conclusions in section 8, which is on page 38. Thank you. And if we look at F, please. In relation to all the variations in body position of Mr Bile and the officers, I would suggest this fits with my explanation as to the fluidity of the control and restraint process, and that there were indeed times when Mr Bile was face down, and the officers were at times placing pressure on him to keep him on the ground. However, I do not believe this was constant or prolonged. Now, I appreciate that I'm taking you through this reasonably quickly, and I've taken a snapshot of the restraint. But from this, do you see that Mr Graves recognises that there are alternative versions that have been given? 2 police officers and Mr Nelson, who we've heard was an eyewitness, who talk about their impression of what happened during the restraint, and PC Walker on the other. And on the basis of the statements of Tomlinson, Smith and Nelson, Mr Bile was remembered to be on his front, with Mr PC Walker lying over his upper body during the restraint. PC Walker's description was of PC Walker being on his knees, with his upper body over the subject's right shoulder, with Mr Bile lying on his side. Now, do you remember the letter of instruction that I drew to your attention?
I certainly remember you drawing it to my attention, and generally the
Let's have that back on the screen
points that you
for
drew
the
to my
moment.
attention.
If we could go back to COPFS, there it is. And if we can look at the section on page 7 out of 12, which was the restraint on the ground. And if we could look at the restraint on the ground at the end, yes, thank you. The very bottom of that, there's a reference to the Snapchat footage that was available, and the Crown specifically drew attention to the fact that from that Snapchat footage, it appears Mr Bile was lying on the southern pavement on Hayfield Road, surrounded by 5 officers, and the 6th officer, believed to be PC Walker, appears to be lying lengthwise on top of or beside Mr Bile. Do you see that? His high visibility clothing visible momentarily. So the Crown Precognoser who instructed Mr Graves, Alistair MacLeod, drew his attention to the Snapchat footage, drew his attention to what he gave an indication, well, it appeared what he could see. Obviously Mr Graves had the versions of Tomlinson and Mr Nelson and PC Walker available, and he recognised as part of his report that there was, let me just see what he said, differing accounts. In relation to this aspect of the restraint, restraint is obviously a very significant matter in relation to the Crown recognition. It's a very significant matter that you've sought expert opinion on from Mr. Graves. And the precognoser, Mr. MacLeod, has drawn attention to the Snapchat footage, which some could view as very significant, and has drawn attention to Mr. Graves to the fact that it would appear to show PC Walker lying lengthwise on top of or beside Mr. Bio. I'm not asking which is right or which is wrong, but would you agree that this is a very significant matter that should be addressed as part of a consultation with Mr. Graves, looking at the differing accounts, looking at the Snapchat footage and what's been said by the Crown that it shows, and resolving that issue in terms of working out what Mr. Graves' evidence and what his opinion is in relation to the restraint, because you have these different hypotheses. Do you think that would be something that you would really want to discuss with Mr. Graves at consultation?
Obviously, you've taken me to a series of passages. I noticed in passing in his report, he actually makes up, as it was flicking through, he makes a point about there being different factual hypotheses, and it being ultimately for the, I think if I caught it as it went past, for the Crown to resolve those. But certainly, if I were faced with an expert who was expressing a view on one hypothesis, but I had evidence that supported a different hypothesis, I would want to explore that with the expert. Equally, if I've got an expert who's expressing a view on different hypotheses, I might want to explore that at a consultation. But I do go back to the comment I made earlier. I've got immensely experienced Crown Counsel who's exercising her professional judgment in how to approach these issues and questions. I'm afraid, other than recalling in very general terms that there was an issue that arose from her report to me that invited some further inquiry, and I'm afraid I can't remember what that was, with the restraint expert. I'm not sure I can really assist much further.
I don't want you to think I'm criticising Mr. Graves. He recognises within his report that there are differing accounts. And would you agree that one of the ways that those differing accounts can be resolved, as you mentioned the word hypotheses, is that a recognised technique where lawyers can explore one factual hypothesis and the implications of that, but they can explore another on the assumption these facts exist? What would your opinion be?
Perfectly usual way to approach issues with an expert.
Right. And so if that hasn't been specifically set out in a letter of instruction, is that the type of approach you would expect to be explored during a consultation?
Yes, I mean, a consultation would be an obvious way to tease out the implications of different hypotheses. There may be other ways of doing it, but one may well get the best out of it by way of an exchange at a meeting.
So you wouldn't expect the expert to decide which version's correct, but you would ask the expert to help you understand if version 1 is correct, what's your opinion? If version 2 is correct, what's your opinion?
Yes, unless you have a view as to which is the correct hypothesis. I mean, equally, I would expect, if you've got a view of a hypothesis and the expert appears to be proceeding on a different hypothesis, you would want to bottom that out.
Right. So if your view of one factual hypothesis was that the officer was lying lengthwise on top of or beside Mr. Bio, that is a hypothesis you would want to explore with the expert, even if he had not fully addressed that in his report.
Well, I mean, one would certainly want to make, one would want to make sure one had the expert's opinion on the, as it were, the best hypothesis that the Crown had of the factual circumstances.
And so in relation to any consultation with Mr. Graves, would you expect the issue of restraint and the positions to be addressed perhaps in some detail as part of the consultation?
Well, I mean, taking what you've shown me, I can see that there are issues there that could be resolved at consultation. And I should say, I'm not trying to be I'm just conscious I'm being asked to express a judgment on or express a view about things which were done by experienced professionals on the basis of being taken very quickly to documents.
I know there's a lot of detail on the screen. I'm not asking you to form a concluded view on the outcome, obviously.
Yes.
Just asking you if it's the sort of issue that you think questions should be asked.
Well, it's certainly the sort of issue that, in my own professional practice, I would seek to resolve, unravel through a consultation with an expert.
Thank you. And we know also that there was a precognition. And is it the sort of issue that may also be addressed at precognition?
Yes, indeed.
And we have consultation notes in relation to the consultations with Mr. Graves. If that issue does not appear to be addressed as part of that consultation, would I be right in thinking you would direct us perhaps to the APCC?
I would ask a question. Yes, I mean I'm, I hope not being.
No.
Yeah, I mean I'm very conscious. Yeah, I had an immensely experienced prosecutor engaged in this case. I'm upon whose judgment I placed and place reliance. If there are questions about the judgments that she made in the course of the inquiry, then it's really for her to explain her thinking.
Thank you very much. I'd like to move on. Could you give me a moment, please? I'd like to move on now, and I wonder if it would be possible to rise early today to allow me a chance to reflect on further questions. I will not finish the remainder of my questions tonight, even if we continue. And because I'd like to move on to a completely different chapter, I wonder if it would be possible to
Very
have
well.
some time.
We'll continue with your evidence tomorrow morning at 10 o'clock, Mr. Wolffe.
Yes, that's
Thank
right.
you.
Thank you.